Hello, everyone. I am going to share my screen here. Got a little.
Hear me?
Hey, Teresa. So we are covering agency today, and kind of specifically kind of talking about buyer agency and when you represent the buyer versus seller, some different scenarios. So just as a reminder, if you ever have questions as I'm going through anything or want me to stop and cover anything, just shout out, unmute, and let me know, versus doing it in the chat, because I sometimes don't see the chat. So yeah, don't be afraid to just pop in and let me know when you want me to go over something again or if you have a question. So talking about buyer agency and again, just as far as when you represent the buyer versus seller. Oops. So first thing I want to bring to your attention is that you do have the ability to become an accredited buyer representative. This is kind of another piece to your license that you can say that, hey, I've got this accreditation. It's through the WRA. Let me know if you want me to share the link. Otherwise, when you're in the WRA website, under education, there's this designations and training tab. So you can see some of the additional trainings that they offer that just gives you a little more knowledge, shows that you're kind of the expert in this kind of area. So something you're interested in, take a look. Looks like they got their next course coming up in October, and I would imagine it's all virtual. So just wanted you all to be aware that that is available.
Did it say a 2-day training? I think it said, Kimmy.
Yes, it looks like this, full days.
And what's the typical cost on that? I was trying to see your screen.
Here,
I see it.
So $260 for member, which you're all members of the WRA. So 2 live classroom credits. And again, I would imagine they're going to do these webcasts as well. So so as far as, just today and what we're going to cover, understanding the difference between selling agent and buyer's agent, that customer versus client. Do I have an understanding of what multiple representation and designated agency is, that piece of the buyer agency agreement? And that's also found in the listing contract. And then do I know how to disclose that I represent the buyer? So these are just some things that we're going to cover today. So when you are meeting with a buyer for the first time, it is so important that you have these buyer consultations. So this is the initial meeting that you have with the buyer, whether these are people that they're personal friends that you've known for years, or maybe it's somebody that you've met at an open house and you're sitting down with them for the first time. It's so important to have this buyer consultation. One, to discuss this buyer agency agreement. So making sure that these buyers understand what they are getting by signing a buyer agency agreement. If they sign a buyer agency agreement, they are becoming your client. And I'm going to show in a minute some different handouts that you can show to the buyer, and I will make these shareable to all of you as well. Just as a visual aid of explaining, okay, if you choose to sign this buyer agency agreement with me, you are a client, and therefore these are the services that I must offer you. Otherwise, in the state of Wisconsin, as a agent, if you don't have a buyer agency agreement signed with that buyer, then you are automatically an agent of the seller. So by default, you're working in the seller's best interest unless you have a buyer agency agreement signed with that buyer. So let me pull up here. I've got a few different examples, and again, I will make these available. So this is just one that kind of outlines buyer agency. So it says in Wisconsin, a home buyer can choose to work with a buyer's agent or a selling agent. Either way, your agent is specially trained, professional, licensed by the state of Wisconsin, who is obligated by law to treat all parties to a real estate transaction fairly. So a selling agent, if you work with a selling agent, there's no contract between you, the buyer, and the agent. There's no buyer agency agreement signed. You're going to receive what's called a disclosure to customers that lists the fair treatment duties owed to you and indicates that the selling agent is the home seller's agent. So I'm going to pop over to zip form right now so you can see what that looks like. So if the buyer is choosing not to sign a buyer agency agreement, they don't want that representation, they do need to be provided with this disclosure to customers. And again, this just goes over the duties that agents have to all parties. So the duty to provide services fairly and honestly, to provide reasonable skill and care, to provide you with accurate information about market conditions within a reasonable time frame, etc. So again, if the buyer isn't signing a buyer agency agreement, by default, then you are the agent of the seller, the selling agent, and the buyer is a customer, and they would need to be provided with this form to sign. So you would sign as the agent, and then the buyer would sign down below. So this is simply a disclosure. It's not any kind of agreement that they would need to pay a commission or anything like that. It's purely a disclosure. Jump back over here to that form or that handout. So next thing covers is the buyer's agent. So it's telling the buyer, if you're working with a buyer's agent, you are the buyer's agent's client. You and the buyer's agent sign a WB36 exclusive buyer agency agreement that includes a disclosure of real estate agency. The disclosure lists the fair treatment duties owed to all parties and the duties owed to you as the client, and indicates that the buyer's agent is the agent of the buyer. The buyer's agent works for the interests of the home buyer, but also must know how to work with the listing agent. So as a buyer's agent, so these are some of the additional duties that a buyer would receive by being a client. Buyer's agent can give a negative opinion or critique of the seller's property beyond disclosing defects. They can recommend or suggest an offering price or give you an opinion about whether a particular house is priced too high or too low. Structure the offer and draft offer provisions with the buyer's best interest in mind. Recommend and assist the buyer with negotiation strategies for the best price and terms. Disclose all information and research a property's history and liens so the buyer can make an informed decision, and give advice within the scope of the agent's expertise as a licensed real estate professional. So this is just a really great overview, I think, of what are those additional duties to you as a buyer if you sign a buyer agency agreement. I think the simplest way to put it, when you get questions or kind of some pushback from buyers about wanting to sign a buyer agency agreement, is simply, okay, if you don't sign a buyer agency agreement, I don't work in your best interest. I work in the seller's best interest. So my duty is to the seller and to get them the best offer possible. So most buyers want that agent in their corner who's working in their best interest. So typically then that's an easy way to get them to sign a buyer agency agreement. So this is just one example of a handout. Here's another one that kind of has, so if the seller is the client versus if the buyer is the client, what are some of the differences here that you can offer as far as a service perspective. This is a nice one that I will share with you all. Let's see. And then the last one, this is one that I always included in my buyer consultation folders. This is through the WRA. It's called Your Rights as a Home Buyer or Seller. And again, it goes through what is the difference between a client-agent relationship versus a customer-agent relationship. And it goes through and breaks down all those duties that an agent must provide when a buyer is a client. So this is just a nice visual that you can go through with the buyer during a buyer consultation. The other important thing about a buyer consultation is hopefully this is where you're getting your buyer agency agreement signed. At the very least, you are going through this agreement with them so that they understand, again, why it's important for them to sign this agreement with you, and as well as just the different components of it. What exactly are they signing? So I always include one of these in my buyer consultation folders. I'm going to cover with you today just some of the main points that you would want to hit with your buyer during this consultation. So line 1 essentially addresses, are you acting as the buyer's agent or a tenant's representative? So this agreement does include both. If the buyer is looking at rental properties as well as homes to purchase. So if you don't strike either, then both apply. So if they aren't sure, they might be looking at rentals, then just leave them both open, and you can fill out the tenant's representative section, which is a few pages down. What's really important, so this box right here, it states if client has contact or has had previous contact with an owner, a firm, or its agents in locating and or negotiating the acquisition of an interest in property, and client's contact with those parties results in the firm not collecting full compensation under this agreement from the owner or the owner's agent, client shall be responsible to pay any uncollected amount. Essentially, this piece is where a reminder for you really too is to ask that client, that buyer, have you signed any buyer agency agreements with any other firms? Have you walked through properties? Have you negotiated with any other agents or sellers on any specific properties? And if the answer is yes, then you need to get more information, because let's say that they had walked through an open house 2 days prior to you meeting with them, and they talked with the listing agent or that agent who was at the open house about the property. These buyers were really interested. They're thinking about writing an offer. You are going to want to maybe get ahead of this, because essentially the listing agent could argue that they have procuring cause. They have started negotiating with this buyer before you, A, have this agreement signed, and B, you didn't introduce this property to the buyer potentially. So they could argue that they are owed the buyer's agent commission. And if that's the case, then you might need to address that with the buyer, that the buyer might be responsible for some of your commission if they end up writing on that property. So those situations are always, they can be tricky. So don't be afraid to come to me or go to Steph if you're in a situation where commission, because we never want commission to get in the way of a buyer writing an offer. And you also don't want to, scare a buyer that you might have to pay me thousands of dollars if you want me to represent you. Usually procuring cause issues can get worked out between the firms well ahead of time. It's usually just a matter of, okay, let's do a referral fee. We, again, never let commission get in the way, but it's just important for the buyer to understand that, once they're working with an agent, it's important for them to just see properties with that agent. So advising the client as well that if they are going to go to open houses, make sure they let the agent who's working the open house know that they are working with an agent. Don't reach out to agents through Zillow, Trulia, Realtor.com, that if they want to see a property, make sure they go through you. You are their, you're their agent, and that's your job. So by going through other people in different avenues, they could be at risk of you not getting commission. All right, moving on here. So the next section just talks about the purchase provision. So the purchase price range is simply just a parameter from a discussion standpoint, as far as, okay, what price point are you guys looking in? If the price point is $300,000 to $500,000 and they end up buying a $700,000 house, This buyer agency agreement is still applies. Doesn't matter that they purchased outside of the parameters indicated here. Excluded property. So the buyer does have an opportunity to say, okay, I want to work with you as an agent, but I'm looking in, condos in southeastern Wisconsin, but I'm also looking at a lake home in Heartland. So if I'm finding a lake home in Heartland, I want to work with a different agent. So I'm going to exclude lake homes from this buyer agency agreement, which would mean if I go and buy a lake home with another agent, you're not owed any commission for that. You're not my agent for those types of properties. That's just one example of a type of property that could be excluded from this agreement. Buyers can also exclude specific property. So maybe if their cousins are going to be selling their house, or their parents, and that's a house that they might be interested in purchasing, and they don't want to be, obligated to work with you as their buyer's agent, they can indicate that property here to be excluded from this agreement. And then the limited exclusion properties provides like an end date as far as how long a specific property is excluded. These are just kind of open-ended. Really, it would be until this specific agreement expires. So as far as commission goes, it is important to kind of going hand in hand with this conversation that we had up here about this text in highlighted. It's important for the buyers to understand essentially how agents are paid. So I would say it's important to explain to them that typically sellers are going to pay buyers agents commission. When properties are listed in MLS, you'll see in MLS that there's that co-broke offer of compensation. It says like sub-agent commission, buyer's agent commission. And it's usually 2.4%. Every once in a while, you'll see 2% depending on the market. Sometimes you'll see a flat fee if it's kind of a lower price point property. I have even seen 3% in some cases. So that essentially means the seller is automatically, that's the listing agreement that the seller has with the listing agent. Whether they're charging 5%, 6%, whatever, the seller has agreed to have the listing firm offer 2.4 of that to a buyer's agent. That is, again, only automatic when the property is listed in MLS. If a buyer finds a property that's for sale by owner, or it's excluded from MLS, there is no automatic offer of compensation. So the buyer needs to understand they could be at risk or on the hook for paying your 2.4% commission if the property is not listed in MLS. Most of the time, and we'll get to this question again in a minute, but it is permissible for you as the buyer's agent to say, hey, you can ask the seller. So if this is a for sale by owner, we can ask the seller to pay your portion, your buyer's agent's commission in the offer. And we'll talk in a minute about what that looks like. So, but it's just good for them to know that there's potentially a chance that they could have to pay some or all of your 2.4% commission if the property is not in MLS. Other compensation. So some agents do choose to include like an additional flat fee of $295 or $395, whether that's taken up front or if it's taken at closing. I don't know anybody in our office who takes compensation up front. If anybody is charging additional compensation, it's typically taken out at closing. I know there was one agent out of the Southwest Market Center that she's purely a buyer's agent, really doesn't do any listings. And so she charges, I think like $500 up front. Basically, it's like her retainer that, I'm going to be putting a lot of work on the front end. showing you houses. So she takes that compensation whether they purchase a property with her or not. So if you are choosing to charge a buyer some additional compensation, again, whether it's $300, $500, or a percentage, if you're taking it out of closing, so if you're not going to collect it until closing, you need to be sure that the buyer's lender, if they are financing the transaction, that they get a copy of their buyer agency agreement, because it's money that the lender needs to be aware of, that they're additional money that they're paying, and then that gets cut to you at closing. So that's if you're taking that compensation out of closing. All right, moving on down here, page 2 just kind of talks about general provisions. No need to really get into too much detail. This disclosure to clients, again, I think this is very wordy. I think it's really nice to provide those handouts, at least one example of those handouts, to the buyers versus reading through this line by line. But the next piece that it is important to go really just have an understanding of is this multiple representation section and designated agency and what these 3 choices mean. So this is exactly the same as the listing contract. The buyer has to make a choice of what type of representation they wish to have. So I would learn this, understand this, and then kind of come up with your own script of how you feel most comfortable presenting this to your buyers. When I explain this to buyers, I essentially say that, you know, we have to make a selection of representation and basically how you want to be represented. This first option is the most common option. This essentially says no matter what, no matter who's on the other side, you will always have an agent designated to you, and I will most likely always be that agent. The second option is, let's say hypothetically, I have a listing. So now I'm the listing agent, I'm representing the sellers, and now I'm also representing you, and you are interested in this listing that I have. If you would choose this second option, you're agreeing to allow me to represent both sides, so both you and the seller, but I must remain neutral during that transaction. And again, with this one, the seller would also have to be in agreement with this choice. And then the third option says that the same firm can't represent both sides, so I reject multiple representation. This would mean you as a buyer would not be able to write an offer on a Keller Williams Milwaukee North Shore or a Keller Williams Milwaukee Lake Country property because I am an agent of that same firm. So that's kind of a more, I think, an easier way of explaining it versus going through again and reading through line by line. I would say the most common choice is the first choice. And, but I've had some buyers say, you know what, if you find a property that that you're the listing agent of as well, I have no issues with you representing both sides. So. I have a closing coming up on the 27th. So do I need to get a copy of the buyer agency to the lender to get paid? Only, so this additional compensation is only if you would only need to provide this buyer agency agreement to the lender if you were asking for additional compensation from the buyer. Again, this 2.4 is automatically offered from the listing firm. And so the title company has a copy of their listing contract and they're putting the splits in the closing statement. Oh, thank you, Steph. Sorry. Guys, yeah, if you have any questions, just feel free to unmute and just ask away too, so I don't miss your questions. Perfect. Okay. All right, any other questions on designated agency? Good. Yeah, I would say, just to kind of recap, this is going to be the most common choice. I've been in a situation where my seller said, yeah, we're okay with you representing the buyer as well as us if you have one. Most sellers then will say, you know, are you willing to reduce your commission a little bit in those situations? It can be kind of a disaster, I'll be honest. It totally depends on sellers and buyers, because when you're remaining neutral between the parties, you're essentially not really acting as an agent. You're just you're the mediator between the two parties. You can't, you know, act in buyer's interest over the sellers and vice versa, which is really hard to do. So I would say the more ideal thing to do would be to just bring in another agent. So if you've got a listing and then you also have a buyer who's interested, you bring in another agent, and even if it's just for that one specific offer, that you have another agent represent your buyer.
Yes.
In that particular
moment later, because Auntie and we got a little problem with the vent.
Hey, make sure you're muted if you don't have a question, so we're not hearing background noise. Okay, moving on here. Page 4 again is just a list of, you know, definitions and things if you need to reference anything. I wouldn't go through this into too much detail, but certainly let your buyer know, you know, after your consultation that they should, you know, they'll receive a copy of this and they're encouraged to read through this more thoroughly. I do want to talk about too, though, it's important that they are aware of the termination of the agreement as well as the extension of the agreement. So as far as termination of the agreement, neither the client nor the firm has the legal right to unilaterally terminate this agreement, absent a material breach of contract by the other party. The client understands that the parties to this agreement are client and the firm. So agents for the firm do not have the authority to mutually agree to terminate this agreement, or amend the compensation or shorten the term of the agreement without the consent of the broker. I would say it's pretty rare for you as an agent, if you and your buyer are, you know, mutually agreeing to, you know, we're not going to work together anymore, just let myself know or staff know, and we'll ensure that the proper paperwork is executed. Essentially, it's just an amendment to the buyer agency agreement, changing that end term date is all we need to do, and then we would need to sign that. And then as far as the extension of the agreement, so similar to a listing contract, the buyer agency agreement term is automatically extended for a period of 1 year as to any protected property under this agreement. And protected property is identified at the top of this page, which is the subject of a written proposal by buyer. So if a buyer writes an offer on a property, if a buyer views the property with the owner or owner's agent, or directly negotiated for by buyer. Direct negotiation means communicating with the owner or owner's agent regarding any potential terms. And the last piece is located or negotiated for by the firm or its agents, but only if the firm or its agents deliver the description of the property to the buyer in writing no later than 3 days after the earlier of expiration or termination of this agreement. So kind of similar to, again, protected buyers for a listing agreement. So honestly, I have not ever seen like the extension of the agreement term be executed. Again, this would mean that if this buyer agency agreement expired and then the buyer 2 weeks later goes back to a property that you showed them and wrote an offer again and ends up closing on the property, you could be owed a commission for that protected property. So not ever seen that happen, but it's just important for buyers to understand that that this is a piece of the agreement. Page 6, this is the whole rental provisions section. So kind of similar to that first page with regards to the kind of the search parameters for a property. You can do the same for a rental property. And then the last page is just referencing delivery of documents. Email is going to be the most common. So including your the buyer's email address here, your email address here, and then the term of the agreement. So the start date and the end date. Really the biggest thing I would say is you really want to get this signed before you start really showing properties to the buyer. Once you start showing properties, you want to be able to provide those agent duties, you know, talking about what your opinion is of the price, providing the buyer with, you know, market information so they can make an educated decision on the offer price. All those things that are outlined here, you know, what am I able to do as a buyer's agent? It's ideal to have that ability when you're showing homes, not just at the the point of the offer, writing the offer. I think a lot of agents wait until the buyers are going to submit an offer or draft an offer to get the buyer agency agreement signed, which I would say that is the absolute latest you should get, you would need to get a buyer agency agreement signed. Because how do you write an offer for an agent as a buyer's agent if you don't have a buyer agency agreement? So definitely need to have that signed before the offer is written, but best to have it signed before you start showing properties, because how do you effectively serve that buyer if you're not their agent? Because again, if you don't have the buyer agency agreement signed, by default, you are the agent of the seller. So when you're showing properties to a buyer, you're technically supposed to be working in the best interest of the seller. So all right. Okay, so just kind of covering again the responsibilities as buyer's agent. So your responsibilities now equal that of the buyer. Doing a CMA, a comparative market analysis, research the home and the area that the property is located in. You know, talk about pricing, look at zoning, look at potential assessments, the use of the area, any development in the area, understanding what the municipality will and won't allow. As your your buyer talked about wanting to put a fence up. You know, what are maybe some different ordinances in the municipality that, based on your conversations with the buyer, your buyer would probably want to know about. Understanding the motivation of the buyer. So is your buyer looking to buy and hold and live in this house for a long time, or are they looking to buy and resell quickly by, you know, are they flippers? What is the resale implications of the purchase? You know, if they're buying a home that's, you know, been sitting on the market for months and you kind of think, you know, why? It's because 2 of the bedrooms are in the basement or whatever it is. You know, having those conversations with the buyer so that they understand that, hey, when you go to resell, that this may be an issue for you guys. Train tracks in the backyard, things like that. Understanding the buyer's loan program and the ramifications of them. So kind of, I would say the biggest thing, understanding the difference between a conventional loan and an FHA loan. Understanding that with FHA loans, they can be, those appraisers can be a little bit more, what's the word I'm trying to think of? They're picky about different things, you know, so if you're looking at older homes and you're seeing a lot of paint peeling or maybe some safety issues, just a kind of a heads up, hey, you know, the appraiser for your loan is going to probably point out some of these things. So just a heads up that we need to be prepared for that with negotiating with the seller if we get to that point. And then as a buyer's agent, you're able to point out more facts about the home. All right, offer written in favor of the buyer. So when you're writing the offer for the buyer, you're always thinking about negotiating in favor of the buyer. What's in my buyer's best interest? So on lines 1 to 2 of the offer to purchase, I'm gonna pull that up right now. This is the first place, I shouldn't say the first place, potentially the first place that you're disclosing you're the agent of the buyer. If you've noticed on showing time, when you're scheduling properties, it usually asks you the question of who do you represent? Are you the buyer's agent? You know, have you not yet determined this yet? So that really is the first place that it's asked. But really the first place that you must disclose is in the offer. And this is on lines 1 to 2 of the offer, where it states that the licensee drafting this offer on this date is one of these 3 options. Are you the agent of the buyer? This would mean you have a buyer agency agreement signed. Or are you the agent of the seller? Meaning buyer has chosen not to sign a buyer agency agreement. They have chosen to be a customer and you have provided them with a disclosure to customers. Or are they the agent, or are you the agent of the buyer and seller? Meaning this, you have a listing agreement with this seller and a buyer agency agreement with the buyer. And both parties have agreed to that second option of designated agency with, I should say, multiple representation without designated agency. So identifying lines 1 to 2, who you are the agent of. Then as far as, again, negotiating and writing this offer in the best interest of the buyer. So with the inspection contingency, appraisal contingency, the testing contingencies, you are indicating whether or not the seller has the right to cure. And we've had these conversations a lot in these different, inspection contingency trainings, et cetera. And as we've talked about, it does kind of depend on the market. But if you are, you're writing this offer for a buyer, if you're not in competition, writing the inspection contingency and stating that the seller shall not have the right to cure is in the best interest of your buyer. Same thing with appraisal. It allows the buyer to have the final say as to whether they want the transaction to continue or not. If you give seller right to cure, it's in the seller's hands to determine if the transaction moves forward. If, for example, an inspection contingency buyer has to deliver notice of defects, seller is going to be able to say, yep, I'm going to move this transaction forward. We're going to cure everything, or no, we're going to kill the deal now because we're not going to cure the defects. So just keeping in mind those things as far as how do I write the best offer for my buyer. And then as a buyer's agent, you can suggest different negotiation strategies. So might this be a good situation to use an escalation clause? Okay, the seller isn't offering a home warranty, but do we want to ask for a home warranty plan? And again, just general pricing strategies. So all different things that you're able to do when you have that buyer agency agreement with the buyer. All right. Next piece to talk about, buyer agency and FSBO, or for sale by owner. So if you have a buyer that finds a property that's for sale by owner, you still work for the buyer. So the seller is essentially unrepresented. So down here I included that the seller should be provided with the disclosure to customers. If one of the parties does not have representation, they should be signing disclosure to customers. So you work for the buyer, but you can work with the seller, meaning you can provide the seller with a real estate condition report, a blank one, addendum S if it's required. So you can provide them with those forms to complete to assist the buyer in the transaction. And then if ultimately buyer and seller come to terms and you have an accepted offer, you can offer to work with the title company, to provide them with the paperwork that the title company needs, et cetera, to get title ordered and all that. And sometimes, like for me, I've done 1 or 2 FSBO transactions. I much prefer to kind of have the control, knowing that the title is all being taken care of. If it's a regular listing and they have a listing agent, you can pretty safely assume that the listing agent is handling things as they should, but you never really know with the seller. So who's unrepresented. With FSBO transactions, I'm going to go back into zip form here. As far as commission, so we talked about how in the buyer agency agreement that, most cases when a property is listed in MLS, there's the automatic offer of compensation. But of course, with for sale by owner, that automatic offer of compensation does not exist. So that needs to be addressed. Otherwise, the buyer is responsible for paying 2.4% or whatever is indicated in the compensation section of the buyer agency agreement. So it is permissible to ask the seller to cover that for the buyer. It just need to ensure that that's included in the offer. So when you're in additional provisions in zip form, if we click on this pencil icon, I'm going to pull up our clause library. And then I click on this scroll icon. This is going to open up the clause library. It's into the offer to purchase category. And then I'm going to search for sale by owner. And then insert. And it says seller agrees to pay blank %. So I would just insert the percentage here, 2.4% of the purchase price, or maybe there's a flat fee that we're going to ask the seller to pay, but it's typically going to be a percentage. Seller agrees to pay 2.4% of purchase price to Keller Williams Realty at the time of closing to be applied toward buyer's brokerage fees. If this is not included in the offer on a for sale by owner transaction, the buyer could be responsible, unless you can negotiate with the seller later on, could be responsible for paying the full commission. And then just a note about the 2.4, it is permissible to reduce your commission down to 2% on buyer agent commission. So, any questions on that? All right. So the last thing I'm going to do, then I'll open it up to some more questions. I'm going to go through some different urban legends. Let me do this. So first urban legend, being a buyer's agent means automatic procuring cause. So the truth is that a buyer agency agreement does not supersede or dictate procuring cause. So this is kind of talking about that, we talked about the buyer agency agreement, and it's important to ask the buyer the question of, have you seen properties with another agent? Because procuring cause is who should receive that 2.4%? Who's owed that? Most cases, it's the buyer's agent who showed the buyer the property, wrote the offer, and then helped close the transaction. Procuring cause is defined as the series of uninterrupted events. So who caused the buyer to make the offer that resulted in the sale of the property? And there is no one act that determines procuring cause. So just because you have a buyer agency agreement with the buyer does not give you procuring cause for any property that the buyer ends up purchasing. You need to be sure that you're, with your buyer from the beginning. You can't just say, okay, I've got this buyer agency agreement signed, and let them go off and see properties with other agents and expect to get paid. You will send, if you do it that way, you're going to, probably not win any kind of procuring case argument, and the other agent is going to prevail. Potentially, you could argue and take it to small claims court that the buyer owes you commission because they signed this buyer agency agreement, but that is totally separate from procuring cause. And again, if you're ever in a questionable procuring cause situation, just let me know, let Steph know, and we'll help you work through it. All right, the next urban legend. In the offer, buyers' brokers are prohibited from asking for the seller to pay their fees. So we actually just went through this. The truth is that we as brokers or agents may ethically suggest or recommend that the buyer ask the seller to pay some of the buyer's broker's entire fee. And the buyer may condition the offer upon the seller paying the buyer's broker's fee on behalf of the buyer as a seller's expense at closing. And again, this is most common in FSBO transactions. You don't have to be a buyer's agent to work with a buyer when the property is a FSBO. So I get this question a lot. Well, once in a while I get this question. More specifically as, hey, I've got, a friend who's looking to sell and they already know a buyer and they just want me to do some paperwork. and they'll just pay me like a flat fee, but we're not going to do a listing agreement and the buyer is not going to be represented. I'm just going to do all the paperwork. Not permissible. If there's not a buyer agency agreement or a listing contract, then the licensee can't be involved in the transaction. The licensee has to, you as the agent have to have an agreement with one of either the buyer or the seller. I'm going to read some more about this one. So there is a whole code it's the REIB 24.025 that talks about this. Yeah, I don't want to go any further into that. So you can't just help people with the paperwork. You have to have an agency agreement with one of either the buyer or the seller. So if the buyer doesn't want to be represented, again, this would go back to the being a selling agent to the listing contract, meaning the buyer would be a customer in that situation. A buyer cannot fire a buyer's agent. The truth is they can. So buyers have the power to revoke a buyer agency contract at any time. This is because an agency contract, such as the WB36, is a personal service contract based upon a special relationship of trust and confidence in the broker. When a buyer directs a broker to stop searching for property, the broker must obey the instructions. And I would say same thing goes for a listing contract. When a seller says, you know what, we want to terminate this contract early, same thing. It's an agency contract and they have the right to do so. So if you're in these situations, don't hesitate to reach out to myself or staff, and we can help you work through those details. All right, do I have any other questions at this time? I will be sure to share this file with you guys. So again, it goes through, there's like 2 different kind of buyer handouts. This is a great, just kind of a question for you or questions for you to, it's why do I want to be a buyer's agent? So there's some questions to go through of things I need to know before I start working with a buyer. Essentially kind of about everything we've covered today. This is kind of an overview. This is another example of the customer versus client, a handout for your buyers. This is an overview of that accredited buyer's representative training class that we talked about in the beginning. If you're interested in that, just kind of some of the perks to getting that, what you can kind of advertise is with this certification. And then here's a list of the urban legends that we went through. So before you all go, I'm going to make a list of who was all here, and I will email this information out to you guys. Hope you all had a great 4th. Like we have a lot of awesome Lake Country agents on today.
Yeah, Kimmy, I can get you the Lake Country email addresses.
I think I've got your roster, so I'll be good.
Great.
Awesome. Well, if there's no any other questions, then I will see you guys next week.
What's the topic next week, Kimmy?
Next week, we are covering advertising and lead generation with compliance, as well as just an overview of all of our MLS rules.
Oh, that's cool.
Being in compliance with those MLS rules.
All right, that's cool. Thank you.
Yeah, you're welcome. All right.
Thank you.
Okay.
Bye.